Welcome to Frank Bruno Law. I'm Frank Bruno. I'm an elder law and estate planning attorney in New York. Today I'd like to speak about the interesting dynamic of inheritance and divorce law. I just posted a blog post about this and I want to give a little more context. Before I do that, if you'd like to ask me a question, if you feel that you need to ask me a question, please go to callfrankbruno.com. I'm looking forward to hearing from you and answering any questions that you may have. So the article that I wrote is really speaking to the question of is inheritance divisible in divorce, right? So in divorce law, there's the general rule of equitable distribution. Equitable implying fair. That means anything that we have should be divided equitably. And most courts very broadly define that as 50-50, right? It seems to be fair that we divide things in half. Now, equitable does not require it to be 50-50, so each side may in fact argue against 50-50 distribution. Now, inheritance is not marital property unless you do something to change it to marital property. That's a commingling the inherited property or transferring it in some way. And sometimes we can best describe these things by examples, right? Because we have the interplay of divorce law and equitable distribution compared to the laws of inheritance. So, if a person inherited $1 million and they inherited it today and put it into a joint account, but removed it tomorrow, well, it was probably an issue of convenience. It was probably stress or de-stress, right? Because they inherited this money. And at least in my example, to inherit $1 million, that person was probably, besides wealthy, they must have really loved you. So that's a momentary, or at least day thing, right? So $1 million went in. Now, if the $1 million was inherited today, deposited today into a joint account, and was not removed for a year, I don't know. That's a fact-specific question. Let me go to the opposite end. $1 million was put in the account today. 20 years from now, the couple gets divorced. Yeah, I think that's clear that ceased to be inheritance and it became a marital asset because it was in the joint account for 20 years. So one day, probably not, or definitely not. I'll go on a limb and say that. This is not legal advice, right? This is a video. I play a lawyer in real life, but on the internet, it's just informational purposes only. So put the money in today, take it out tomorrow, fine. Put it in today, take it out 20 years from now, no. I give an arbitrary time frame of 10 years, no. Definitely marital property, right? It's my opinion. 9 years, yes. 8, 7, 6. We get all the way down. How about a year? I don't know. Again, why was the money left in there for a year? Now, I just used a sum of money, and that could have been cash or brokerage accounts. The thought process and the considerations would be the same if it was property, but in the next example, would it be an investment property? Would it be a marital residence? Could it be that you inherited a home and then the husband and wife moved into that home? Well, at what point does the inheritance stop being inheritance and change into a marital asset? Well, we have to take a look at that. If a person did inherit into a trust and then moved into that property, if it was in the trust for the duration of the marriage, it would never become marital property. Right? It's like living in your friend's house. Doesn't matter if you're there for 30 years. It never becomes yours. Right? So if you have a question about your situation, please give me a call and we can speak about it together. Thank you very much.